Greetings to my fellow criminal enthusiasts. Today, we're going to talk about the case of People of the Philippines versus Francisco Abarca with the General Register number 7443 dated September 14, 1987. So this is a case of an appeal from the decision of the Regional Trial Court of Palo, Leyte, sentencing the accused appellant Francisco Abarca for death for the complex crime of murder with double frustrated murder for the deaths of Kingsley Paul Ko and two others. This is how the story goes. Mr. Kingsley Paul Ko and the wife of the accused, who is Francisco Abarca, and the wife's name is Jenny. So Mr. Paul Ko and Jenny had an illicit relationship. So the illicit relationship began while the accused, Mr. Abarca, was in Manila reviewing for his 1983 bar examinations. So Mr. Abarca had a dream to become a lawyer one day. His wife was left behind in their residence in Tacloban, Leyte. On July 15, 1984, the accused was in his residence in Tacloban, Leyte. On the morning of that date, he went to the bus station to go to Dolores, Eastern Samar, to fetch his daughter. However, he was unable to catch the first trip in the morning, so he went back to the station in the afternoon to take the 2 o'clock trip, but the bus had engine trouble and could not leave. So Mr. Abarca then proceeded to the residence of his father, after which he went home. He arrived at his residence at the VNG subdivision in Tacloban City at around 6 o'clock in the afternoon. Upon reaching home, the accused found his wife, Jenny, and Mr. Kingsley Ko in the act of a sexual intercourse. When Jenny and Ko noticed the accused, Mr. Abarca, the wife pushed her paramour, who is Mr. Kingsley, who got his revolver. So now Mr. Kingsley has a gun. Mr. Abarca, who was then peeping above the built-in cabinet in the room, jumped and ran away. The accused went to look for a firearm at Tacloban City. Mr. Abarca went to the house of a PC soldier, C2C Arturo Talbo, arriving there at around 6:30 p.m. He got Talbo's firearm, which is an M16 rifle, and went back to his house at the VNG subdivision. He was not able to find his wife and got there. So he proceeded to the mahjong session, as it was the hangout of Mr. Kingsley Ko. Mr. Abarca found Ko playing mahjong. He fired at Kingsley Ko 3 times with his rifle. Ko was hit, and Arnold and Lina Amparo, who were occupying a room adjacent to the room where Ko was playing mahjong, were also hit by the shots fired by the accused. Kingsley Ko died instantaneously on cardiorespiratory arrest due to the shock and hemorrhage as a result of multiple gunshots on the head, trunk, and abdomen. Arnold Amparado was hospitalized and operated in the kidney to remove a bullet, while his wife, Lina Amparo, was also treated in the hospital as she was hit by bullet fragments. Arnold Amparado, who received a salary nearly $1,000 a month, was not able to work for 1.5 months because of his wounds, and he spent $15,000 for medical expenses, while his wife spent $1,000 for the same purpose. So on March 17, 1986, the trial court rendered the appealed judgment, finding the accused, Francisco Abarca, guilty beyond reasonable doubt of a complex crime of murder with double frustrated murder, and was sentenced to death. So it appears from the evidence that the deceased Kingsley Paul Ko and the defendant's wife had illicit relationship while he was away in Manila, and that the accused had been deceived betrayed, disgraced, and ruined by his wife's infidelity, which disturbed his reasoning and faculties and deprived him of the capacity to reflect on his acts. Because of the findings of the trial court, the accused appellant assigns the following errors committed by the court. First is in convicting that the accused for the crime as charged instead of entering a judgment of conviction under Article 247 of the Revised Penal Code. Second, in finding that the killings was amended by a qualifying circumstance of treachery. So the Solicitor General recommends that they apply Article 247 of the Revised Penal Code, defining the death incited under exceptional circumstances. An illegally married person who, having surprised his spouse in the act of committing sexual intercourse with another person, shall kill any of them or both of them in the act or immediately thereafter, or shall inflict upon them any serious physical injury, shall suffer from the penalty of destierro. If he shall inflict upon them physical injuries of any other kind, he shall be exempt from punishment. These rules shall be applicable under the same circumstances to parents with respect to their daughters under 18 years of age and their seducers while the daughters are living with their parents. Any person who shall promote to facilitate prostitution of his wife or daughter, or shall otherwise have consented to the infidelity of the other spouse, shall not be entitled for the benefits of this article. So the Supreme Court agreed with the Solicitor General and said that the provisions of Article 247 applies to the case. There is no question that the accused, Mr. Abarca, was surprised to see his wife and the paramour, Mr. Kingsley, in the act of doing the sexual thing. So the victim in this case, in the act of illicit copulation, as a result of which he went to kill the deceased, Mr. Kingsley, in a fit of passionate outburst. So Article 247 prescribes the following elements. First, that a legally married person surprises his spouse in the act of committing sexual intercourse with another person. And that second, that he kills any of them or both of them in the act or immediately after. These elements are present in this case. So the regional trial court, in convicting the accused appellant Mr. Abarca of murder, therefore was wrong. So though there's quite a length of time, about an hour had passed between the time that the accused appellant Mr. Abarca discovered his wife Jenny having sexual intercourse with the victim, Mr. Kingsley, at the time where the latter was actually shot, the shooting must be understood to be the continuation of the pursuit of the victim by the accused appellant. So the Revised Penal Code, in requiring that the accused Mr. Abarca shall kill any of them or both of them immediately after surprising his spouse in the act of intercourse, does not say that he should commit the killing instantaneously after. It only requires that the death cause be a proximate result of the outrage overwhelming the accused after chancing upon his spouse in the basest act of infidelity. But the killing should have been actually motivated by the same blind impulse and must not have been influenced by external factors. The killing must be direct by a product of the accused range. It must be stressed, therefore, that Article 247 does not define the offense. Therefore, we conclude that Article 247 of the Revised Penal Code does not define and provide for a specific crime, but grants a privilege or benefit to the accused for the killing of another or the infliction of serious physical injuries under the circumstances mentioned. Punishment, consequently, is not inflicted upon the accused. He is banished. but that is intended for his protection. It shall likewise be noted that inflicting death under exceptional circumstances, not being punishable act, cannot be qualified by either aggravating or mitigating or other qualifying circumstance. We cannot accordingly appreciate treachery in this case. The next question refers to the liability of the accused appellant for the physical injuries suffered by Lina Amparado and Arnold Amparado, who were caught in the crossfire as the accused appellant, Mr. Francisco Abarca, shot the victim, Mr. Kingsley. The Solicitor General recommends a finding of double frustrated murder against the accused appellant, and being the more severe offense, proposes the imposition of reclusión temporal in its maximum period pursuant to Article 48 of the Revised Penal Code. This is where we disagree. According to the Supreme Court, the accused appellant, Mr. Francisco, did not have the intent to kill the Amparado couple, although, as a rule, one committing an offense is liable for all the consequences of his act. The rule presupposes that the act done amounts to a felony. But the case at bar requires distinctions. Here, the accused appellant, Mr. Francisco, was not committing murder when he discharged his rifle upon the deceased. Inflicting death under exceptional circumstances is not murder. We cannot therefore hold the appellant liable for frustrated murder for the injuries suffered by the Amparados. This does not mean, however, that the accused appellant is totally free from any responsibility, granting the fact that he was not performing an illegal act when he fired shots at the victim. He cannot be said to be entirely without fault. While it appears that before firing at the deceased, he uttered the warning words saying, "An waray labot kagawas," which means that anyone who is not related to the issue, they have to go out. For the separate injuries suffered by the Amparado spouses, the Supreme Court, therefore imposes upon the accused appellant, Mr. Francisco, arresto mayor only, which is in its medium and maximum periods, and in its maximum period, arresto to being the graver penalty than destierro. So that is the ruling of the Supreme Court. Hope that you liked our case for today. I will be reading another case on our next video. So if you want me to read more cases about criminal law in the Philippines, please like and subscribe to my channel, and don't forget to click the notification bell. See you next time!